Good morning. This is the House Judiciary Committee. It is the 20th of March, Saturday at 10:37. We're going to have a relatively brief voting session, he said. Hopefully. What we're going to do is we're going to start with House Bill 75. There was a request for a hold yesterday, so now we are on the bill as amended. Is there further conversation or debate on the bill as amended? Seeing none, we'll take a roll call.
Hello, hand up.
Yeah, you're waving your hand again. All right, Delegate Conaway.
Thank you, Mr. Chairman. I was wondering, can we get a brief overview of what the amendment is going to do, amended bill?
The amended bill would get rid of the primary election for circuit court judges and say that they have to file for election in August of the year in which they are running.
Thank you very much.
Okay. Delegate Moon.
You know, actually, I do. Thank you, Mr. Chair. I do want to say something, explain my vote. You know, I actually appreciate that I had the evening to think about the bill and gut check it with some colleagues of mine where I know they have, like me, a long-standing distaste for judicial elections entirely, and have been on the position in Maryland. I have, since the first day I got here, not wanted these elections at all. And I've always signed off on any of the bills that have tried to get us closer to getting rid of these elections. And it's become hyper political with everything from the Federalist Society to the American Constitution Society to matters of racial, ethnic, and gender diversity at the head of this. And I know that people are going to want to look at what we do on the basis of the last election. And in Montgomery County, it was a contested election where someone who won my party's primary did not end up succeeding in the general. And it was the opposite in other counties. And at different points in the state's history, you would have gotten different results on these. And as a result, me and my colleagues are all over the place on this issue. And I really wrestle with what happens when you just delete one of the elections. But I have to say, when I just paused and thought about it for a second and thought about what was going on in the election in Montgomery County last year, where I was being told I should I should endorse and support the progressive judge, and other people were then trotting out photos of candidates with different political party signs and presidential candidate signs around them. And it's a real bad look. And I also don't like the lawyers standing outside of the polling places, handing out literature when you know those lawyers are appearing before the same judges and that's how the financing is done. But I don't think it's consistent with my beliefs to then vote down getting rid of that primary and the extra cost and the campaigning that happens with that extra election. But I know there will be some back home who feel I'm disadvantaging or maligning insurgent candidates. And believe me, I come from a heart of in my heart of insurgent politics, but I don't like these elections. So I'm going to be a yes on the bill. Thank you, Mr. Chair.
Thank you very much. We're going to go ahead and take a roll call. The Vice Chair.
Yes.
Delegate Arakan.
Yes.
Delegate Bartlett.
Yes.
Delegate Cardin. Delegate Cardin.
The amendment, bill amended.
It's on the bill. I'm sorry. Delegate Cardin? What your vote?
On the bill or on the amendment?
We're already favorable on the bill as amended.
Okay, I'm just going to say that I tried to look at the bill and here's if there's some unconditionality about making the deadline for registration. So I was going to offer that amendment, but I decided not to. And for many of the reasons Delegate Moon stated, I'm going to vote in favor.
Just for the committee's benefit, and I spoke with Delegate Cardin not that long ago. He was considering an amendment that would have put the filing deadline in these cases earlier. It would put it earlier, but council indicated that there is existing case law, and it's Mandel versus Bradley, that indicated that a earlier filing deadline for the general election was Court of Appeals to be unduly burdensome. And so that's why he did not submit the amendment. But we're going back to the roll call now. Delegate Conaway.
No.
Delegate Cox.
No.
Delegate Crutchfield.
No. And I just want to say that I appreciate the spirit of the bill, but I'm very concerned about taking out the processes. Even though, of course, the whole gain is to try to make this as nonpartisan as possible, but my vote is a no.
Delegate Deborah Davis.
No.
Delegate Fisher.
Mr. Chair, am I allowed to explain my vote and vote?
Yes.
Okay, I just wanted to say on record that I'm not exactly sure what the best process will be for us to have more fair and, nonpartisan elections. It's a difficult thing. I think over the last 3 years, we've had so many judges and advocates come testify in a various amount of bills. So my hope is that this bill does lead to greater outcomes for Marylanders and representation. I think it will be TBD, to be determined. I think each jurisdiction is going to react to this very differently. And so I'm hoping that this committee will be open to readdressing these issues as they go along, not just this session, but next session, to get us to a better place of justice. But with my concerns and with those comments, I'll be a yes.
Delegate Grammer.
No, and to briefly explain my vote, I think we should stop acting like judgeships are non-political. They clearly are. There are interests in our elections. We get teachers' unions on site handing out the Apple ballots. So if someone's in support of a judge, I think we're lying to the public by acting like this relationship doesn't exist. I think that judges are a good old boy network, just like any branch of government. And I think this is a real strike at insurgent politics. It's going to make it nearly impossible for the average person to compete in a giant jurisdiction and win. And that's why I'm voting no today.
Delegate Griffith.
Yes.
Delegate Rachel Jones.
No.
Delegate Lopez.
Yes, and Chairman, to explain my vote, after 3 sessions on this committee, I've heard arguments on both sides for appointments and for elections. I think there's a lot of merits and disadvantages in both of those scenarios. And I'm voting yes, because I know that as someone who represents a district that has almost a majority of immigrants or foreign-born folks, that those are folks who typically are going to be independent voters more than other populations. And those are folks who are not going to participate in the same type of partisan politics. And so I'll be voting yes to help decrease one layer of partisanship in the process.
Delegate Malone.
Yes.
Delegate McComas.
To explain my vote, I have listened through this through a number of years, and I think the most effective witness I've ever heard has been Billy Murphy. That said, I am a no. And I understand that the chair's done a lot of work, but I'm a solid no at this point.
Delegate Moon.
Yes.
Delegate Shetty.
Yes.
Delegate Cham.
No.
Delegate Watson.
Yes.
Delegate Williams.
And of course, the whole slew of for DWI, DUI, the youth treatment program, as well as anger management and domestic violence.
Sorry, Mr. Chair. I'm on my phone.
Psychological, forensic, clinical.
I'm sorry. So the bill, I just want to say this. And so I think I mentioned this previously. I do remember the testimony from Billy Murphy. I think last session, that was my first session when I was here. And I really am concerned about, I understand everyone's concerned about politicizing the process. And I actually do share a lot of those same concerns about politicizing the process. But I also have the same concerns with regards to making sure that our bench is diverse and ensuring that there is diversity of thought in our bench and diversity of perspectives. I think we're naive to say that judges, while yes, they should be operating within the bounds of the law, also, also are people as well and bring their backgrounds and experiences to the table as well. I've been very torn about this bill. I actually like the original version of the bill. I think I said that before, to open it up to independents because I think their voices should be heard as well. And I just don't know what the fix is to depoliticize the judicial process because it really should be depoliticized. And I know just the history in my county where I'm from, it's just a very controversial thing. And so.
Oh, sure. The random urinalysis testing or the testing when they came in for the evaluation, absolutely. That is done on site. The laboratory itself is not done.
Figure out, did my thing got go?
Yeah, we did lose your video there for a second, and that's okay.
About 24 business hours. Sure.
We lost your video again. She was disconnected from the Zoom. She was on her phone. Yeah, she's coming back in.
All right, I'm back, Mr. Chair.
All right, thank you very much. That's okay.
So I'm sorry, as I was saying, I just, given the history with my county and just everything that's at stake, and I appreciate the chair's amendments. And like I said, understand the desire to depoliticize the process, which I'm not objecting to, but unfortunately, I'm going to have to be a no on this one.
Thank you. There are presently 11 votes in favor of the favorable and votes opposed. The chair votes aye for 12. All right, we're going to go now to House Bill 855.
Did that pass, Mr. Chair? Sorry.
It did.
Okay, thank you.
We're going to go to House Bill 855, Wade's Law. I've been in conversations with members of the committee, and I've heard concerns. We do not normally take an oral amendment. However, because we are where we are in the process, and because of the conversations that I've had, I think this committee has moved the Wade's laws in the past. It passed the committee unanimously in 2017. I believe to keep this moving, I think we've got an agreement to move this forward. And with that, I will recognize Delegate Crutchfield, who would like to make an amendment.
Thank you, Mr. Chair. I had some concerns about this legislation, a couple of concerns. One is that I wanted to get an understanding of what threatening injury really meant here. And I also was concerned with the fact that, life-threatening injury. And I was also concerned with the penalty. I felt that the 18 months was a bit high for a claim of life-threatening injury, and I want to move an amendment to reduce down the penalty to 12 months. And And so I'd like the committee to consider that amendment to move the penalty from 18 months to 12 months on this.
All right, there is an amendment. It has not been put in writing, but given where we are in the process, and I believe
Mr. Chair, move the amendment.
there's a motion for amendment and a second. Is there further discussion on the amendment? Delegate Moon?
No, I'll save it for
Never
the vote.
mind. Okay. All in favor of the amendment, please raise your hands. Delegates Atterbury, Griffith, Malone, Shetty, Jones, Lopez, Arakan, Davis, Watson, McComas, Bartlett, Cham, Moon, Crutchfield, Fisher, Grammer, Cardin, Conaway. Anyone opposed? Delegate Cox. All right, the amendment is adopted. Is there further discussion on the bill as amended? Now, Delegate Moon.
Okay, sorry. Thank you, Mr. Chair. So I just want to understand the leap of law we are proposing to take here. And it appears to me that, you know, even with terrible consequences, that the category of cases we would like to move into the criminal realm is a category of accidents that had nevertheless catastrophic results. But I want to be clear that the intent of the bill is to criminalize accidents, unless I am missing something. And only car accidents, no other type of accident.
I'm sorry,
Food vessels.
I'm sorry,
Is it
somebody else was
correct
jumping in.
that this is about accidents and only car accidents, but they would move into the criminal realm, coming with a jail term, prison term?
I mean, there are other examples where a car accident, we have vehicular manslaughter where somebody can receive jail time if they kill somebody while they're in their car. We have existing criminal negligence where if somebody dies, then that is connected to the higher standard in criminal negligence, that they are subject to jail time. If you're in an accident that results in a serious bodily injury and you leave the scene of the accident, that is subject to.
I have to say, I Googled it last night, criminal negligence, just to see what types of cases we're talking about. And it was like, you didn't turn signal. I don't think it was what we think we're doing. And so that's why I want to be clear on what cases we think this language brings into jail.
All right. Let me recognize some other people here. Delegate Arakan.
Thank you, Mr. Chair. So my understanding is that if these victims in these accidents had died, then there would have been criminal charges. Because they were maimed, you know, within an inch of their life, there's nothing for them. So it's the same behavior, but simply because the person was close to death but didn't die, we're not penalizing the person who caused it. Right now, and with this bill, there will still be a penalty, as I think there should be a penalty. Oh my gosh, gun accidents next. You're reading the chat section? Oh Lord. Anyways, that's my understanding of how this bill is going to work. Am I wrong? Am I wrong there? Or is that exactly what this does?
I believe that is what the bill does. It is extending criminal negligence to situations where people sustain a serious bodily injury.
Yeah. Okay. Thank you. This is a great bill. Move favorable.
All right.
Second.
All right. We have the motion. We voted the amendment, but we're going to go through the conversation here. Delegate Malone.
My good fellow delegate from Hartford County made my point. This is already basically a criminal action. It's just, but for the grace of God, the person wasn't killed. But it's devastating to the person who is severely injured and to their families. And I concur that it's a good bill and should receive a favorable vote.
Delegate Cardin, then Crutchfield, then Griffith.
Thank you, Mr. Chairman. So just reflecting on a little bit of what Delegate Moon said, you can already take a civil action against somebody and recover not only costs, but also other damages, economic and non-economic damages if you are injured in this situation. Is that correct, Mr. Chair?
If there is an accident and someone, I mean, the standard here is gross negligence. So that presumes then that they would be, yes, it's beyond just ordinary negligence, but they just need just ordinary negligence in order to go forward with the civil claim.
Right, but then with gross negligence, they would also be able to claim additional damages, would they not?
I'm sorry, you cut out.
Damages because of gross negligence? Would they be able to claim because of gross negligence? I'm gonna step out.
I'm just, with respect, Delegate, yeah, I would need you to stop the car as talking about a bill about gross negligence when driving a vehicle that could potentially cause injury. And I'm going to move to Delegate Crutchfield to give you a chance to stop. Delegate Crutchfield.
Thank you, Mr. Chair. Over and over, I've heard from my colleagues an explanation of what they believe life-threatening is. And again, I will just proffer, there is no real definition. I mean, we're assuming things, bodily injury, but to what extent? And so that's my concern with this legislation. And that is the reason why I put forth the amendment. I'm just very concerned about what we are classifying life-threatening injury as.
Right, Delegate Griffith and then the Vice Chair.
Thank you, Mr. Chair. I'll be very brief. I think this kind of ties back to some of my frustrations. I don't know if anybody in our districts have worked to get traffic circles or traffic lights, but we have a number of these issues in my jurisdiction. And I'm always told, well, not enough people have died at the intersection to qualify the investment. I just don't understand why we need people to die to get justice. This would allow us to get justice without people actually having to die. So that's why I'm supporting it.
The Vice Chair.
Thank you, Mr. Chair. So I do support the bill. We passed it in 2017. There was no action in 2018. And then unfortunately, there was a serious life-threatening injury. She testified before us today. She was paralyzed. That happened in 2018. Then the Senate passed it in 2019. And I know the good Senator, Mary Beth Carrozza, when she was in the House, actually started this legislation. But I just want to read, so I'm looking at the definition of criminally negligent, acting in a negligent manner with respect to a result or circumstances when the person should be aware but fails to perceive that the person's conduct creates a substantial and unjustifiable risk that such a result will occur, and the failure to perceive constitutes a gross deviation from the standard of care that would be exercised by a reasonable person. And so criminal negligence resulting in a life-threatening injury requires a finding beyond a reasonable doubt that the person, so that's a high standards, bad driving created a substantial and unjustifiable risk to human life. And Delegate Crutchfield is right. There is no statutory definition of life-threatening injury. It's based off of case law, and the leading case is Todd v. State. And they say life-threatening injury is a term that can be understood and applied in everyday sense. Therefore, evidence in that case indicating that a child in the car defendant hit head-on suffered a serious head injury that required numerous surgeries at a famous hospital because they were too complicated to address at the local hospital were ample to support a conviction. So I appreciate Delegate Crutchfield's concerns. I appreciate I support her amendment, and I do support this legislation. Thank you, Mr. Chair.
Delegate Conaway, then Davis, then Cardin, then Grammer.
Yes, Mr. Chairman. So we're still talking about vessels in this bill?
There are vessels and cars, correct?
And cars, okay. And just for educational moments, so talking on a hands-free device while you're driving, could that be considered distracted driving?
Yes.
Thank you.
But that's not the same.
Delegate Deborah Davis, I hear you, Delegate.
That was just my question, that's all.
Delegate Deborah Davis.
Mr. Chair, this question is to you as a prosecutor. There's been a lot of talk about how there's no criminal penalty unless you kill the person. That is not true. Can you tell us what else you would charge a person with if they were negligent, criminally negligent?
Right now, if they are criminally negligent and driving a car, there's the penalty if they kill someone, but there's not a penalty if the person sustains a serious bodily injury.
Not related to the injury, but there'd be a list of other charges that you could charge them with if they were negligent.
Like what?
First of all, whatever the negligence was.
Because negligence alone isn't a criminal act.
If they were speeding and so it could be reckless driving, right? I mean, all of these things that pile on to create the negligence are also chargeable offenses and criminal offenses.
Well, but I think that the difference, I think it's a question of the speeding, you get a ticket, you pay a fine. The reckless driving, you pay a fine. I think the question becomes whether there should be some kind of jail penalty. And that's, I think, the point of the bill. So can they bring other, let me be clear. And just to, Delegate Davis is right in saying that there can be other citations that can be issues. That is correct. Are there other jailable criminal charges that can be brought? No, not at the moment. It's not an assault. It's not an assault, for example, because it's not. Delegate John Carden, who has stopped.
Thank you, Mr. Chair. Yeah. Okay, so my first question was, you can certainly file a suit civilly and get additional damages because of the gross negligence, can you not?
I believe you could get greater damages if they can prove that it reached the level of punitive damages.
Right. Okay. That's number one. Number two is you can also charge with failing to failing to avoid an accident, which would be another finable charge, another, I think, $500 fine. Not jailable, but finable. So
Right.
there are a number of different charges you could have against that could avail the prosecution of thousands of dollars in fines. And the question that we have is to benefit, I guess, the victim. Do we want to put this person in jail? Do we want to be able to put this person in jail because of his acts? And the only thing I will add to that conversation is it's not just driving. I mean, there could be a slippery slope argument here. There are acts that doctors do or nurses do or construction workers do or other people that do services do that could result in gross negligence, injure a person, and should, because of their actions, should then because we're now setting a precedent that you should do it for people who were driving, should you do it for people who were acting in furtherance of whatever action they were doing? And so that's the concern that I have. And I think that I understand that we are just basically, we're extending this to people who didn't die in terms of victims, but we're also potentially extending this to people who weren't driving because we're setting a precedent that could be addressed in a further year.
All right, Delegate Grammer, then Williams, then Malone.
Thank you, Mr. Chair. I just wanted to say, I think this is sensible. It gives us a remedy where we don't currently have one. We all supported Delegate Crutchfield's amendment, which I think is very reasonable to not have an extended penalty on this. And seeing that, I think it's a reasonable bill and we should all support it.
Delegate Williams, then Malone.
Yes, I just was going back to Delegate Conway's question though, with driving while you're, using your device though, distracted driving is not the same as being, I guess that's my question. Is that I don't think that's the same as being criminally negligent though.
Mr. Chair, I think there's a difference.
Go ahead, the Vice Chair.
Thank you, Mr. Chair. So, so Jake's law deals with the texting and driving and distracted driving, which whenever that was passed. And all you have to show is
I know the sponsor of that bill.
Was it you? Oh, you want to talk?
That's the part where she was asking about Jake's law. It has to do with you have to be proved to have been texting or otherwise engaging your phone while in the car, and then you cause death or serious bodily injury.
So this bill that we're on, Wade's law, is more stringent than that. And you have to show criminal negligence, which requires additional bad driving, which is a greater degree of negligence. So it is different. I don't know if that answers your question, Delegate Williams.
Yes, it does. Thank you.
Thank you, Delegate Malone.
Just briefly, first to Delegate Cardin's point about being able to sue. The problem is I haven't done PI work in a long time, but PI attorneys joke about the fact sometimes you have great liability but no insurance, or you have poor liability and you have insurance. Maryland only requires, I think it's something around 2040, and that doesn't even mean the person has 2040. And what that means is $20,000 is the maximum recovery for one person, and maybe 25 now, and that's assuming the person has insurance. So that doesn't even touch a serious injury. I just wanted to point that out.
All right, here's the deal.
And MedCai has taken no position. They're
holding the floor for us. We need to get this over with here relatively soon.
Move the previous
question.
Delegate Moon. I hear Delegate Moon. I see Delegate Moon, and then we're going to call the question.
Thank you, Mr. Chair. I'm sorry. I don't like to double dip, but there are questions being asked about specifically what the bill does, and I just want to understand this again because I thought that texting while driving and things like that could fall under this criminal bit, and so I just when I'm reading the bill itself, it seems to be just a reasonable person standard, and it's about foreseeability. And I think when you listen to the testimony on the distracted driving bills, everyone is saying this is foreseeable, dangerous behavior. And so that's why I say, if you just Google the term criminal negligence and see the types of examples. You'll see not just various types of cases about driving, but you'll see all sorts of other stuff. Standards of care at nursing homes, accidents that happen at the doctor's office. And again, other states have criminalized those behaviors. And so I just want to be very clear that it's not clear to me we aren't talking about some very common driving offenses. Again, I'm not endorsing those behaviors, but I want to be clear about what leap in law we're seeking to take here. So I intend to vote against the bill.
All right, the Vice Chair, and then we got to stop. The Vice Chair.
Thank you, Mr. Chair. I just want to clarify for Delegate Moon that criminal negligent behavior, I'm not sure what you're Googling, but under the Maryland statute, criminal negligent behavior resulting in a life-threatening injury requires a finding beyond a reasonable doubt that your driving created a substantial and unjustifiable risk to human life. And that is a higher standard than the standard required for texting while driving or distracted while driving. So it is different.
Okay, I said I was going to call the question. and that's what I'm going to do. We're on the bill, and on the bill as amended. Do a roll call. The vice chair,
Yes.
Delegate Erican,
Yes.
Delegate Bartlett,
Yes.
Delegate Cardin,
No.
Delegate Conaway.
I had my hand raised and I understand what you're saying, but is on page 2 is line 9, is that still? Can I ask this question while we're voting? And it's in reference directly to your comment, Mr. Chairman. You referred to engaged on your phone under Jake's law. So I'm wondering, would the reasonable person understand it if you're engaged on your phone, that might be negligence?
I believe you'd have to that would be something that you would have to prove before a jury, but I believe it. I believe that would constitute gross negligence.
Well, yes, Mr. Chairman, thank you. So I vote yes.
Delegate Cox,
Yes.
Delegate Crutchfield,
Yes.
Delegate Deborah Davis,
No.
Delegate Juanica Fisher.
No, and briefly, Mr. Chair, I just wanted to say that I do appreciate and support the concept of this bill. I just think that the penalty and the tailoring would have been great to have time to sort of tailor this, but I do respect the sponsor and the intent.
Delegate Grammer,
Yes.
Delegate Griffith,
Yes.
Delegate Jones.
No.
We are not done after this, by the way. There's one further thing. Delegate Lopez,
Yes.
Delegate Malone,
Yes.
Delegate McComas,
Yes.
Delegate Moon,
No.
Delegate Shetty,
Yes.
Delegate Cham,
Yes.
Delegate Watson,
Yes.
Delegate Williams.
Yes.
See 14-5? All right. The bill is passed with amendment. We have an amendment that was given to the vice chair related to House Bill 89. The amendment, this is House Bill 89, deals with diminution credits available for people who complete certain full courses of education while they're being incarcerated at the Department of Correction. What the amendment would do would be to not, or they're already in the bill, and I think that there was an error made yesterday. Already in the bill, people who are required to register on the sex offenders registry are already not allowed to take the 40-day credit or the 60-day credit.
I think, Mr. Chair, he was trying to make a point. I'm sorry to interrupt.
Yeah.
To make a point not in the bill. He was trying to make a point about current law, which current law, they can earn credits. That he was trying to be whatever.
Yes, which I think, if I'm not going too far, was perhaps why you demonstrated
Well, he
some
caught me off
frustration
guard
yesterday.
because we had an agreement. He was going to go out there and make a statement that he was special ordering it, and I was going to say yes.
Okay.
It's like had a whole back and forth, which instead
All right.
of saying
There is an amendment that Delegate C.T. Wilson would offer that would prevent people who have been convicted of first-degree murder from being able to take this 40-day credit. I wanted to bring this before the committee. I believe that there certainly will be some people with concerns about this on the floor, but I wanted to hear from people on the committee about what they thought and then decide whether or not to take this as a friendly amendment or not. With that, I'm happy to take comments. We're going to stop no later than 11:21. Delegate Juanica Fisher.
Thank you, Mr. Chair. I did not have the joy to be in the Public Safety Subcommittee chaired by our Vice Chair, but I know that they worked on this bill I think this bill has been worked on for 2 years. I think it's fair. I would be unfavorable against this amendment. And the real
I
policy.
should have mentioned that the bill sponsor is okay with it.
No, I understand that. I know that.
That's fine.
But I'd be unfavorable against this amendment because to me, I look at it from, a bit of a broader view in the sense of if your penalty on a crime is not life imprisonment without the possibility of parole, you are coming out at some point, right? At some point. And I think that the diminution credit concept as a policy concept is to incentivize people to get their education. It's a tool that helps corrections, keep people on the right path within the facility, keep people doing things that are positive and not just the manual labor things that we have folks doing. And so to me, even though the crime is horrendous, and I agree with, the punishment, all those things, the reality is though that person is leaving at some point. And I would want people reentering our society with education, with tools, to not continue to be honestly on the taxpayer, but to be able to provide themselves and to contribute to our society as a whole. And that's why I would be against this amendment because I think that we need to give people an incentive and support in pursuing their education. And I think when we start, and this issue is difficult. We've had many different delegates outside of this committee have concerns. I think when you start picking and choosing what crime should and what crime shouldn't, pain is pain and suffering is suffering, and it's hard. And I think all the issues we discuss in this committee are hard. I think once you start that ravel of this criminal doesn't, this criminal does too much, I think you're going to have a ton of concerns and a ton of amendments and a ton of people commenting on who should get it and who should not. And I think it's really hard to quantify pain. So that's my comments. I tried to be brief, Mr. Chair. Thank you.
Delegate Deborah Davis.
Thank you, Mr. Chair. I'll be brief. Also, I concur with Delegate Fisher, and I will be voting no, basically due to process. We've got to have some process.
Delegate Rachel Jones.
I was just going to ask if you could show the amendment again, or not again, but do you have it to show, or could you read it one more time?
There's Charles. The vice chair, I think, has the paper version of the amendment. It literally, yeah, go ahead.
The amendment would remove first-degree murder, people convicted of first-degree murder from being able to participate in this program in terms of they can still earn a degree. So we're not saying you can't earn a degree. You cannot earn the 40 credits, but you can still earn a degree and you still get 5 days just for doing that for each program. And you also, there are enough other types of credits. They can earn 50% off their sentence already. So, they can still do that. I will also say, I know we got to go. So, we have 2 members that are going to stand up who've lost a son and a grandson. So be prepared. They are going to be standing up if this is not taken as a friendly amendment. I will also say, taking first-degree murder and attempted murder was a consideration in drafting this bill. But the Senate sent what they sent over, so that wasn't included in this, but that was an original consideration.
Perhaps worth mentioning that the 2 bills will be in a different posture when they crash together with each other. Delegate, Delegate Conaway.
Thank you, Mr. Chairman. I'm against the amendment. I don't consider it to be friendly. I know there's a disparity in treatment, there's false imprisonment, there's no incentive to change a person's behavior if you take away the diminution credits. People have a lack of education. They don't even know what they're up against and what they really did based on their reading comprehension level. So with that, I would be against the amendment. Thank you.
Delegate Grammer, and this will be the last comment.
Thank you, Mr. Chair. I just wanted to ask a philosophical question. What's worse, a sex crime or murder? If we're going to pass this for sex crimes, why wouldn't we do it for a much more egregious offense? We shouldn't do things because it's popular for politicians to do it. We should do it because it's the right thing to do. That's why I'm going to support the amendment.
All right, I'm calling the question. I don't think, what I'm going to do is I'm going to ask people I'll just roll call it. Let's go. It's the best way to do it. All right, so to accept, the question is to accept it as a friendly amendment. Delegate Atterbury,
Yes, if I think the sponsor's okay with it, I'm a yes.
yes. The sponsor did indicate she's fine with it.
Thank you.
Delegate Arakan,
Yes.
Delegate Bartlett,
Yes.
Delegate Cardin,
Yes.
Delegate Conway,
No.
Delegate Cox,
Yes.
Delegate Crutchfield,
Yes.
Delegate Davis,
No.
Delegate Fisher,
No.
Delegate Grammer,
Yes.
Delegate Griffith,
Yes.
Delegate Jones.
Can you come back to me?
No.
Sadly, no.
No.
Okay. Delegate Lopez,
Yes.
Delegate Malone,
Yes.
Delegate McComas,
Yes.
Delegate Moon,
No.
Delegate Shetty,
Yes.
Delegate Cham,
Yes.
Delegate Watson,
No.
Delegate Williams,
Yes.
6 opposed, 14 in favor. We'll accept it as a friendly amendment. We are done. We are going to the floor. Thank you all very much.